my very distinguished colleagues in the Supreme Court, Justice Sanjay Kaul, Justice Ajay Rastogi, Justice Jiten Maheshwari, the Honorable Union Minister for Law and Justice, Shri Kiran Rijiju, Shri R. Venkatramani, Attorney General for India, Mr. Vikas Singh, President of the SCBA, Shri Pradeep Kumar Rai, Vice President, Mr. Rahul Kaushik, Honorary Secretary, Mr. Rohit Pandey, the Joint Secretary, Yugandhara Pawar Jha, the Treasurer, my very distinguished former colleague and sister, Justice Indu Malhotra, Solicitor General, Mr. Tushar Mehta, the law officers who are here, and all the distinguished members of the bar who are present. Why do we meet on the eve of Constitution Day to celebrate this event? And what is this great significance that we feel towards the Constitution that leads all of us to congregate here in such a large measure? You have the text and the letter of the Constitution, the bare book of the Constitution, which we handle in the court, which is given to us every day. We have the judge's interpretation of the Constitution, the judgments which we as judges deliver. Then there is the citizens' engagement with the Constitution, whether it be on the traffic light, whether it be in the election of the members of the legislature, in the states or in the center, whether it is in terms of their demand for better health facilities, whether it is in terms of their expectation of a good and clean environment and good education for their children, secure conditions of living, safety for their families. But then in our court, there is a dialogue over the unfolding of the Constitution which takes place every day between the lawyers and the judges. That, to my mind, for us in this community of judges and lawyers, and we have also allowed the law minister entry into this community, very closely guarded community. This dialogue about the Constitution between judges and lawyers every day, this defines how the essential values of the Constitution unfold in the lives of our citizens. And those values are the values of dignity, equal respect for citizens, our sense of fraternity towards each other, and above all, liberty and equality. Every day in the court, seemingly small issues pertaining to our citizens, whether it is someone's quest for pension, someone's quest for bail, someone's quest for a job which has been lost or which has to be secured, someone's quest for admission to a medical college. All these small, seemingly small issues actually unfold the working of the Constitution. Many other Supreme Courts across the world would be somewhat surprised at the kind and diversity of the issues which our Supreme Court deals with. A very distinguished judge of a foreign Supreme Court who came to visit our court once told me that I was in the court when there was a dispute over a telephone bill. He said, well, our courts will never consider raising an issue pertaining to a telephone bill in the highest court of the land. Well, there may be two questions as to whether the Supreme Court of India should be resolving telephone bills in the Supreme Court. And it's quite a debatable question. But the most important thing which we need to realize is that our courts have a different place in our society. And the Constitution has so configured our courts so that we form a part of the lives, the daily lives of our citizens. And therefore, if you see the way our judges in the Supreme Court, in the High Courts approach the work which they are called upon to do, no case is too small for our judges, and I dare say no case is too large, because ultimately you apply legal principles to every case, however small, however large, but it is in the application, the equal application of the same legal principle to every citizen of India that we generate a sense of confidence that those who do not have voices are heard in our courts, those whose faces would not find expression outside may be heard and seen in our courts. So it is in these interfaces between our bar and bench, in our daily lives, in the course of our working, that we unfold the true and intrinsic worth and merit of our Constitution. 26 November 1949 was a very significant day because that's the day on which the Constituent Assembly adopted the Constitution. The drafting of the Constitution was a historical event encapsulating the rights, the liberties of our citizens and the dreams and aspirations of our citizens. But above all, our Constitution is an exercise in nation building. And that process of nation building is a constantly evolving task that is never static. The Constitution as we see it today is very different from the Constitution which even the framers of our Constitution imagined it would be. And I dare say, long after we have laid down our jobs and our lives, the Constitution will be very different from what we imagine it is going to be today, because the Constitution is constantly evolving to meet the new social realities of the time. The Constitution has a very important role for the judiciary, and can you imagine a judiciary without the lawyers? When you talk of the judiciary, you must understand that the bar and the bench are equal stakeholders in the process which goes on in our court. When we as lawyers and judges interact with each other, we send one very important message to all our citizens. And that message is that in this mission of providing justice to our common citizens, we stand together. As judges, we come and occupy these offices for the term that the Constitution gives us, but never do we as judges ever believe that we stand apart from the bar. And never does the bar believe that it stands apart from the citizens. So though we have a discipline of our own in the law, our law has its own logic, sometimes which is not understandable to citizens. Though sometimes the phrases which we use in our judgments may not be found in dictionaries, yet in this mission we stand together as members of the bar and the bench. And it is that hope, it is that mission which I bring to you on my first Constitution Day since my assumption of office. Now, the confidence of our citizens in the judicial process is also determined by how efficient we are in the way we organize our work in our judicial institutions, not just in terms of the important judgments which we deliver. For the citizen, ultimately it matters whether their case is heard by the court. How long does the court take to hear their cases? How long does the court take to dispose of their cases? So just as we deliver important judgments, I believe that it's crucial for us as administrators of the judicial institutions to make sure that we are efficient in delivering outcomes to our citizens. Ever since I assumed my responsibility as Chief Justice of India, my endeavor has been to streamline the processes of the court towards speedy disposal of cases. I've attempted to carry forth the legacy which was handed over to me by my distinguished former colleague, Chief Justice Uday Lalit, to refine the listing process with a view to bring down the pendency. We are trying to ensure that defects are notified to advocates on the same day that a case is filed. After taking due scrutiny of the working of the registry, we have taken several remedial measures. In taking these remedial measures, I consulted all my colleagues, because I do believe that every one of the judges of the Supreme Court brings a great and wide experience as lawyers first and foremost, as members of the district judiciary, as Chief Justices of the High Courts. And I have tapped that experience of every one of my colleagues. The result now that we are able to verify about 200 matters every day as opposed to less than 100 matters a few weeks ago. Last Sunday, every member of our listing department, the listing section 1B, stayed back the entire Sunday to clear the arrears of matters. So we must also remember our own registry. In just the last 5 days, the registry officials have worked relentlessly to verify 982 matters. This has ensured that the time required to notify defects has been reduced from 9 days to 2 days. Currently, as of 5 p.m. today, we do not have any matter filed prior to the 24th of November for which defects have to be verified. From the next week, every bench of the Supreme Court will hear 10 bail applications preceded by 10 transfer petitions. There are about 3,000 transfer petitions pending in the Supreme Court. Since we have 13 benches going on right now, our endeavor is to dispose of around 130 transfer petitions every day before the vacations. We also want to ensure that bail matters are listed and disposed of in an expeditious manner, as that deeply impacts upon the personal liberties of our citizens. Apart from changes in listing, we are also trying to set up specialized benches in the Supreme Court to provide speedy remedy to litigants. From next week, 4 specialized benches will be functional in the Supreme Court to deal with motor accident claims tribunal cases, criminal appeals, especially those where the accused are still in jail, land acquisition matters, and direct and indirect tax matters. You will realize that each one of these 4 or 5 categories of cases deeply impact our citizens and their right to speedy justice. So the choice of the category of these cases is also based on the need to deliver justice to our citizens. We need to expeditiously hear motor accident claims because they involve very often simple questions relating to the loss of life and personal disability and the computation of compensation. But where citizens are waiting for years and years for a compensation claim of 5 lakhs or 7 lakhs or 9 lakhs. Disposal of criminal cases is also priority for me because these matters essentially involve questions of life and personal liberty. As we celebrate Constitution Day, I also take the opportunity to reflect on the role of the bar in protecting and evolving constitutional values. Several judgments of our court on constitutional law are considered as landmarks. But these judgments of our court are built on the arguments which are presented by lawyers and the ideas which are presented by lawyers. So in that sense, the writing of the judgment is a sense of the dialogue between the bar and the bench. Members of the bar therefore play a crucial role in bringing novel interpretations of the Constitution before the court and in facilitating the evolution of the constitutional process in India. In drafting our Constitution itself, several members who are members of the Constituent Assembly made their seminal contributions. If we look at the last 75 years since the independence, the contributions made by the distinguished members of the bar across the country are enormous. But the contributions of the bar must not be considered only in the context of the evolution of the jurisprudence by the Supreme Court and by the High Courts in India. Thousands of lawyers working in the trial courts help citizens at the very first stage of the legal system. They work without any social security. COVID brought us into stark reality of how little in terms of social security our lawyers have. Yet they soldier on. While the Supreme Court and High Courts can decide constitutional questions, the working of the Constitution is also dependent on how the processes at the district level are operating. The Constitution works when a citizen is assured of adequate legal representation at the very incipient stage of our legal system. If someone is denied adequate legal representation at the trial level, it is a constitutional right to be heard that is denied to that person. Therefore, as the Chief Justice, I appreciate the role played by the bar across all levels. The Constitution is not just a legal document. It has a social dimension. It has a political dimension. Therefore, the understanding of law cannot be divorced from social reality. We must acknowledge that law in the past has also worked as a source of oppression. For instance, the Criminal Tribes Act criminalized millions of tribes whom we know now as denotified tribes. The social law of the time treated millions as untouchables. When we celebrate the Constitution every year, we must be conscious of the histories prior to the adoption of the Constitution. Therefore, the values of our Constitution must be understood and evolved in the sense that the law no longer acts as an instrument of oppression. And it is tasked to every young member of the bar, every senior member of the bar, and every judge to ensure that the law becomes a source of justice and not a law which becomes a source of injustice. Lawyers around the world have used the potential of the Constitution to win rights for the citizens. The experiences around the world show that the building blocks of people's rights are built through several individual cases. Public interest is thus served not just through PILs, but also in ensuring that citizens have smooth access and experience with the justice system. I therefore call upon the senior members of the bar to take some pro bono cases of poor litigants every year. This practice can be institutionalized, and I am open to a dialogue on it. I also endorse the idea that the curriculum of law schools needs to be evolved so that even the law students can be involved in the facilitation of the legal process. The working of legal aid clinics together with the bar needs to be redesigned to ensure that law students can learn as well as contribute to real cases happening in the courts. This can happen by conceptualizing a scheme where their roles are institutionalized at the district or trial level. From the success stories of legal aid clinics across the world will emerge a new effort to merge legal services with the legal aid clinics in the law schools with the bar. Young law students are full of optimism of our changing world, and we must facilitate the channeling of their energies into their holistic learning as well as in the pursuit of justice. In its constitutional goal towards access to justice, the Supreme Court has been improving its processes with technology, but the court needs cooperation and assistance from the members of the bar in making the court's processes accessible. As we march step by step towards an era of e-governance and online courts, the Supreme Court Bar Association can consider organizing training sessions together with us in the E-Committee for members of the bar in acquainting with the new processes. In particular, it may be difficult for lawyers who come from outside Delhi and from the neighboring regions for their cases in the Supreme Court to be aware of their procedural requirements. Members of the SCBA may take a lead in creating online educational videos which can help lawyers coming from outside Delhi. In terms of technology, the young members of the SCBA are tech savvy, while the young members are taking mentorship and lessons from the senior members of the bar. They can in return assist their seniors in having a smooth experience with online systems and processes in the courts. But we need to create a culture in the bar where lawyers across India are guided and mentored. All of you have come from different parts of the country and made this institution a thriving institution. You have to give back now to others from across the country whom you need to mentor as well. The legal profession is often described as a noble profession, but it must not turn into an elitist profession. Rather, as a constitutional goal, it must support diversity. The constitutional goals ought to be realized in the working of the profession as well. We must have a culture of compassion and dialogue within the legal profession. Society is changing, and so are our institutions. In the area of the Constitution, we must now shed away the legacy of colonial thought and culture within the legal system. We have to make our legal system truly adapt to the local needs, demands and aspirations of our citizens, including in the language which we use. As they say that practice begins at home, the legal profession must shed away its colonial underpinnings. In a country like India, where summers include extreme heat waves as a result of climate change, we must reconsider the strict dress code for our lawyers, particularly in the summer. I am not saying that our dress code should be done away with completely. Of course, there is a decorum of the court, but I am just floating the idea of making our dress more compatible with our life, our weather and our times, so that there is a meaningful discussion on this. In particular, the strictness on attire should not lead to moral policing of women lawyers. The discourse on the Constitution can evolve when lawyers have access to court judgments easily, as their arguments are strengthened by citing precedents. I am particularly concerned by the struggles of young members of the bar who are optimistically joining the profession, but have no means to access judgments and report books. As Chief Justice, I am working towards updating the Supreme Court reports in a timely manner. The copies would be made available online free of cost, so that they would be accessible easily. The law clerks are an integral part of the court now. They assist the judges with extensive research. The Supreme Court judges' library staff cooperate with the request for research material in a timely manner every day, so that the court discussions are made smooth. As Chief Justice, I am trying to see that the judges' library is updated with the latest databases. I am also thinking of having an online remote access to the library database, so that the law clerks can easily access the resources and that the burden on the library staff may be reduced. Members of the academia often complain that there is a lack of communication between the profession and the academia. Well, I consider academicians to be a part of the larger legal fraternity, but as a gesture of my belief, I am considering to set up an annual Supreme Court of India lecture series on the 28th of January every year, as 28th of January 1950 was the day when the Supreme Court came into being. We will invite a distinguished jurist from other jurisdictions to facilitate academic discussions on the global trends on constitution and the legal systems. Finally, criticism about the collegium. I thought I had reserved the best for the last. No institution in democracy or in a constitutional democracy is perfect. But we work within the existing framework of the Constitution as it is interpreted and given to us. And all the judges of the collegium, including me, we are faithful soldiers who implement the Constitution. When we talk of imperfections, our solution is to work our way within the existing system, because we as judges are entrusted with a system which we have to abide by and follow. The President raised a query about, are good people, how would you get good people to man the system? Getting good people to enter the judiciary, getting good lawyers to enter the judiciary, is not just a function about reforming the collegium. Getting to be judges is not a function of how much salary you give judges. However high you pay your judges, it will be a fraction of what a successful lawyer makes at the end of one day. People become judges for different reasons. People become judges because of a sense of commitment to public service. There are some doctors who join private corporate hospitals. There are others who spend their lives working for the All India Institutes of Medical Sciences, for the public hospitals to serve the poor. So becoming a judge is a call of conscience. And getting good people to become judges is first and foremost about inculcating upon the minds of the young members of the bar about the limitless ability which lies in the power of every judge to do good to society. Good judging is about being compassionate. Good judging is about understanding the problems of people. Good judging is about not being judgmental about people whose ways of life you and I may not agree with, including somebody who is in breach of the law. Good judging is about understanding why even a criminal becomes a criminal, which is not to excuse the crime, but to ensure that even when you deliver hard letter justice, there is a defining line which ensures that within the framework of the law, there is a great power which is entrusted to the judge to be of good to others. And I think when we need to have good people within the system, the answer lies somewhere else. And that answer lies in mentoring young people by giving them the ability, the dream, the aspiration to become judges. Not in pursuit of a better life as a judge, or by having that car which the government gives you, or by giving that house which the government gives you. I think that's the least important part of the job, because that's all very transient and it's all going to leave one day. But what leaves, something which does not leave you as a judge, even when you retire, is that sense of fulfillment. Your conditions of service are only so long as you are a judge, but something which is never taken from you even when you demit office is your sense of fulfillment of what you have done for the community during the time that you have been a judge. So I think it's also about changing the culture in the minds of our young lawyers. And we have to make judicial office appealable to our young lawyers by the way we work as judges, by the way we work as lawyers. If young lawyers see senior members of the bar screaming at judges, young lawyers will feel, well, do I want to go there and be screamed at by other members of the bar? On the other hand, if young lawyers feel that judges are given such respect by all segments of the establishment, that will only make judgeship more appealing to them. Likewise, we have to ensure that young lawyers are mentored by our judges. When we as judges mentor young lawyers, we get more than our adequate share of blessings in terms of the smiles which they give you, in terms of the kindness which they show to you inside and outside. When I was down with a very florid attack of COVID in May 2022, I got an email from a group of women commanders in the Indian Navy to whom we had delivered justice. Brother Rastogi and I were on the bench, and then Brother Emar Shah and I took the mantle in another case. And those women commanders sent me a little email and told me that, sir, you have never met us in person, and I'm sure we'll never meet you again in person. But for the justice which you did to us in our case, we are all praying for you and for all other judges in the Supreme Court who have been afflicted by this rather serious ailment which we are all combating in our society today. That, I believe, is the greatest satisfaction of judging. So it is when we share these stories, that's when we will encourage good people to come to the bench, encourage them, tap them, ensure that they accept judgeship, persuade them. And in this task of persuasion, a great deal of mentorship is involved. So it's not just about reforming the collegium, it's not just about giving better salaries. Of course you have to give better salaries, because their cost of living has to be attended to when their children are growing up. I know that. I've brought 2 children up over a career spanning 22 years. But there is something much more fundamental about attracting good talent to the bench. And I thought I must highlight that. And last, the Chief Justice is only the first among the equals. I am blessed as Chief Justice with very dynamic, responsible, considerate senior colleagues with whom I engage every day. So much of the work of the collegium takes place when an agenda is circulated. But so much of the work of the collegium takes place much earlier and much thereafter. When we leave over a cup of coffee, when we share a thought over a cup of coffee. So you must also understand that there is something called a soft culture within the judiciary as well. And we as judges are not really here to only follow the letter of the law by following the processes of the collegium, but for the purpose of ensuring that the soft culture, that sense of constitutional statesmanship between the government and the Supreme Court continues to be in harmony to find the right balance in the selection of judges. We can't be constitutional statesmen if we are only at a point where we are finding fault with each other. We understand that we have a system, we have a constitution, and we need to work our way as constitutional statesmen to finding just conclusions. And I'm sure that with the assistance of very distinguished colleagues who I have on the bench, who have great experience of handling difficult situations, we can handle every situation with a great deal of harmony and social resolution. Thank you very much.
Sir, it was excellent hearing you. Our constitution is still evolving, and it's on this Constitution Day, it's also time to remember the stalwarts of this profession, Mr. Palkiwala, Mr. Seruvai, who had appeared in Keshavananda Bharati that the basic structure of the Constitution cannot be amended.